Hello everyone, welcome back. So, we were discussing the concept of free consent, if you remember. And so far, under free consent, we have studied coercion, where we saw that there is some kind of fraud, where there is some kind of force. Okay, then we saw undue influence, where one party is in a one party who is in a dominant position misuses his authority. Next, we discussed fraud. In very simple terms, fraud is intentional cheating. And I told you that intention is the heart of fraud. And in the last class, we talked about misrepresentation, where there is a false representation made by a party, but without intention. Or in other words, we can say that it is an innocent false statement. Today we will study something very interesting. Imagine a situation where none of the parties lies, or in other words, no party to the agreement lies, or no party threatens, or no party cheats, which means that none of these things happens. Coercion, undue influence, fraud, misrepresentation. Imagine a situation where none of these scenarios exists. Even then, the agreement may be invalid. Okay, and why will that happen? Today we are going to learn that. And the concept is that of mistake. First question is, what is mistake? You keep hearing about this term in your daily life. Mistake, that I've made a mistake, or I made a mistake in understanding whatever you told me. For example, if I tell you something and you say that and you don't understand that properly, then you apologize later saying that, sorry, I made a mistake. I did not understand what you said. That is what is mistake. So we can write it as mistake simply means believing something to be true, which is actually false. Okay, that's it. In mistake, there is no bad intention, no dishonesty, just a wrong belief. And before we discuss this concept in detail, let me give you the golden rule first, which is that when both parties to an agreement, are mistaken about an essential fact of the agreement, then the agreement becomes void. Alright, so far we had seen that in these scenarios, coercion, undue influence, fraud, and misrepresentation, the agreement becomes voidable. But in mistake, the agreement becomes void when both the parties are mistaken. And mistaken about what? Essential fact of the agreement. We are going to understand each of these terms. Void, I'm sure you know, void means as if the agreement never existed, correct? And voidable was when the agreement can be enforced at the discretion of the party who the law has given that right. Okay. For example, when we saw undue influence or fraud, we could clearly see there that the party which has been who has been defrauded, or the party who has been unduly influenced, can decide whether the agreement will go ahead or not. So in those kinds of scenarios, undue influence, fraud, coercion, misrepresentation, agreement is voidable at the option of the affected party or the party who has suffered. But as we just discussed, in mistake, there is no concept of an agreement being voidable. It is purely void. If you take this agreement to a court of law, the court will not enforce it at the discretion of any party. Doesn't matter even if both the parties want to enforce, or if one of the parties wants to enforce, it does not matter. If the moment judge takes a look at this kind of agreement where there is a mistake of fact which is essential to the agreement, the judge will say, I will not enforce. I'm in no position to enforce this agreement. This agreement cannot be enforced. Okay. Now let's understand this with the help of an example. Let's say there are two parties, Rahul and Aman. Okay. Rahul, Aman. Aman has a dog and Rahul wants to buy that dog. Okay, so today, let's say today is 14th Feb. 3:15 p.m. Okay. Both Rahul and Aman enter into an agreement. Both Rahul and Aman enter into an agreement. Agreement is for what? Agreement says that Rahul is purchasing Aman's dog at rupees 10,000. Okay. But at 3 p.m., 15 minutes before this agreement was finalized, at 3 p.m., dog had already died. Okay. And neither Rahul nor Aman, none of them were aware of the fact that the dog has already died. What happens in this kind of scenario? Now they have agreed over something which is no longer in existence. What is the subject matter of this agreement? If I were to ask you, what is the subject matter of the agreement that we are talking about? What will you say? It is clear that the subject matter of the agreement is dog. Okay. Both the parties are deciding to do something vis-a-vis the dog, correct? One party has agreed to buy, one party has agreed to sell the dog. Can we say that dog is an essential fact of the agreement? Is dog an essential fact of the agreement? You would say yes. Dog is the most important fact of the agreement. The agreement is based on the dog. Okay. Now read this golden rule. When both parties are mistaken about an essential fact of the agreement, agreement becomes void. Now question, are both Rahul and Aman mistaken about this essential fact? The answer is yes, because none of them is aware of the fact that the dog has already died. Agreement was finalized at 3:15 p.m. Dog had already died 15 minutes before. So what happens to this kind of agreement? The agreement becomes void. Now, what have we understood from this? We know two things for sure by now. Number one, both parties should be mistaken. Let's write it down. What are the key elements that we learned? Both parties to an agreement should be under a mistake. And second, mistake about what? Mistake about an essential fact of the agreement. Okay, and let me give you another example to help you understand the meaning of essential fact. When I told you that both Rahul and Aman entered into an agreement to buy and sell that dog, okay, one party is selling, other party is buying. Cost is rupees 10,000. Now let's say the actual market value of that dog is rupees 10 lakhs. And both Rahul and Aman are not aware of the fact that the actual market price of this dog is rupees 10 lakhs. And after the agreement is signed, then they come to know that the dog is valued at rupees 10 lakhs. Now, can the parties say that we were under a mistake? The answer would be no. Why? Because money is not the essential fact here. The essential fact is the dog. And the law also says that value is not equal to fact of the agreement. Parties may be mistaken about the value of the substance of the agreement. Okay, what is it that the agreement is talking about? Each and every substance has a value, right? Parties may be mistaken about that. That is completely all right. That will not allow the parties to take the defense of mistake, because mistake can only be of an essential fact. So please remember this: value of the subject matter of the agreement, even if both the parties are mistaken, it doesn't matter. All right. So let's focus on the first point. Both parties should be under a mistake. Now, some of you may think, what is the meaning of this sentence, and what does it want to say? What if only one party is under a mistake? So there can be two scenarios. Mistake, there can be two scenarios. Number one, mistake by both parties. And number two, mistake by only one party. Let's understand the second category first. Now take the dog example only. Aman is selling the dog to Rahul. Aman is aware of the fact that dog has already died. Okay, he is clearly aware. He is not mistaken. Despite being aware of this fact, he signs the agreement to sell the dog to Rahul. Can we say there is a mistake? The answer would be no, because our golden rule says that both parties should be under a mistake. Here, only one of the parties is under a mistake, and that party is the buyer, Rahul. Rahul does not know that the dog has already died, but the seller is aware of it. And the example that we just saw, if it's not a mistake, what is it? It's clearly a case of fraud, correct? Because it is active concealment. Aman was supposed to tell Rahul that the dog has already died. Now we cannot do this agreement, but Aman intentionally cheated Rahul, correct? So that becomes a case of fraud and not mistake. So law clearly says that when there is a mistake by only one party, agreement is not invalid. Okay. What is required for the agreement to become void or invalid? It is mistake by both parties. It has to be a bilateral mistake. And there's a very famous case on this. So there are two parties, A and B. Okay, A is the seller, B is the buyer. Now A has a horse which is called Swift. The name of the horse is Swift. A also has a car, and the car also has the name Swift. Now B wants to buy the car Swift. B wants to buy the car Swift. So B approaches A and tells A, I want to buy your Swift. Will you sell me your Swift at rupees 5 lakhs? Now A thinks that B wants to buy the horse Swift. And as we have clearly seen, B wants to actually buy the car. So are both the parties mistaken here? Yes, both the parties are mistaken. Mistaken about what? Are they mistaken about an essential fact? Again, the answer is yes. They are mistaken about the subject matter of the agreement. One wants to buy the car. The seller thinks that the buyer wants to buy the horse. Now, this is a genuine mistake. What happens in this scenario? The agreement becomes void. And from here, we have this concept. This case gave us the concept of mistake. All right. Now, again, as we saw mistake of two types, let's categorize it further. We saw in terms of the mistake by one party or two parties, we saw one categorization of mistake. Let's look at the other categorization. Mistake can be of two kinds. Again, mistake can be of two kinds. Number one, mistake of fact and mistake of law. We clearly saw that mistake of an essential fact by both the parties will make the agreement void. Again, you may think, okay, fact we understood. What happens when there is a mistake of law? I hope you understand the difference between a fact and a law. Okay, I want to sell my car to you. That's a fact. Okay. Now, let's say there's a law which says that if somebody has to sell a car, they need certain documents to be in place before they can enter into an agreement. That's a law. Okay. Question is, what if there is a mistake of law? Now, take one example. Two parties, A and B. All right. A and B enter into an agreement. Agreement is for what? A is selling his house to B. All right. For rupees 1 crore. Now B's budget is 1 crore. B likes the house, so he goes ahead and signs the agreement. That this is all that I have, and within my budget, I have found this house which I like and I would like to buy it. A also is happy with 1 crore. So A has sold his house to B. Now, when they sold the house, A thought that I was getting 1 crore rupees, correct? And B thought that he was getting the house for 1 crore rupees. No extra money beyond 1 crore. But there is a law in place which says that when two parties enter into an agreement for sale or purchase of a house, then they have to pay some tax to the government, and both the parties have to pay the tax. Let's say the government has passed a law saying that both the parties will have to pay 10% tax on the value of that property. Okay. Now, A got 1 crore, right? A will have to pay 10% tax, which means that A will have to pay rupees 10 lakhs as tax. So how much is A left with now? A is left with only 90 lakhs. Now, B also has to pay 10% tax on the value of the house. I'm not saying this is the actual law. I'm just asking you to imagine that if there is a law like this, which both the parties were not aware of. Now, B will also have to pay rupees 10 lakhs, correct? On the house that he purchased. But as I told you, B's budget was only 1 crore. And had he known that the house that there is a taxation on this transaction, he would not have purchased a house worth rupees 1 crore. He would have probably purchased a house worth lesser than 1 crore, correct? Now both the parties were under a mistake of fact or mistake of law. Is this a mistake of fact or law? The answer is this is a mistake of law. They were not aware of this taxation law. Now that they have gotten aware, both of them want to cancel the contract. They are saying that no, this is not a good deal for us. Most of our money is going in tax. So we don't want to do this deal. Question: what happens to this agreement? Law says, Contract Act says, mistake of law is no excuse, which means that now they will have to go ahead with the transaction. The agreement is perfectly valid. They will have to pay the tax to the government. They cannot cancel. The agreement cannot become invalid in this scenario. So that is the crucial distinction between mistake of fact and mistake of law. Mistake of fact by both the parties will make the agreement void. Mistake of law does not make the agreement invalid. You have to remember this. Mistake of law will not make the agreement invalid. Okay. But one important thing here that you must notice, we're talking about Indian law. If you're talking about two Indians entering into an agreement, then we have to care about Indian laws, correct? If I'm selling my house to you and both of us are Indians, all I need to know is the Indian law. Should I be concerned about what is the law in Germany with respect to sale or purchase of house? The answer is no. Because I'm doing this transaction in India with an Indian citizen and I'm also an Indian citizen, okay? So mistake of Indian law, and that is why law expects you as an Indian citizen or a resident to be aware about or to be aware of the laws of India. You cannot be ignorant of Indian laws and later try to take this defense that, okay, I was not aware of the law, hence this agreement should be invalid. Law does not permit that. Law expects you to know the law. Okay. But again, some of you may think, what if there is a mistake of a foreign law? Now imagine a situation. There are two companies, A and B. Okay, B is a bank. B is a bank in Germany. And A is an Indian company. Now A wants to take a loan from B. B is a bank. B can give loans, correct? So both A and B have agreed on the terms and they enter into an agreement. Okay, agreement to, let's say, loan of rupees 10 lakhs. A takes that. So both the parties enter into an agreement. So the paperwork is ready. It's signed. The agreement is in place. Now, both A and B get to know. They were not aware of this fact earlier, but now they get to know that whenever an Indian company takes a loan from a bank in Germany, before they agree on the paperwork or before they sign the agreement, German law requires that, let's say there's a German law. It says that before a German bank one second, hold on. There's some network issue, just a second. So before a German bank gives a loan to a foreign company, which means a company which is not situated in Germany. German bank has to take approval from the German government. Let's say there's a law like this in Germany. I hope you understand. There's a law in Germany which says that if any German bank, any bank which is in Germany, if they want to give a loan to anyone who is not from Germany, then before they give the loan or before they sign the loan agreement, the German bank has to take permission from the German government, the government in Germany. Now, neither A nor B were aware of this law in Germany. Question: what happens to the loan agreement that they signed? It is a mistake of law, correct? We just saw that mistake of law is no excuse. And the agreement will proceed. Agreement does not become invalid. We talked about this just a while ago. But there is one distinction. Earlier, in the previous case, we talked about mistake of Indian law. In this scenario, we're talking about mistake of foreign law. Indian Contract Act says if there is a mistake about a foreign law, then the agreement can become invalid. Then let's say if A tells B that sorry, then I will not be taking this loan from you because the process has become too lengthy now. Can the German bank say that no, we signed an agreement and therefore you will have to take the loan from me? Indian Contract Act permits A to withdraw or to cancel this loan agreement because both A and B were not aware of the German law. And therefore, we know that mistake of foreign law can be an excuse. Again, the logic is very simple. If I'm an Indian citizen, I cannot be expected to know the law in Germany. All right? So, we have seen all the important elements with respect to mistake. One, both the parties should be under a mistake. Second, mistake about what? Mistake about an essential fact of the agreement. Third element, if there is a mistake of Indian law, then what happens? The agreement does not become invalid. Mistake of Indian law is not an excuse. Fourth, mistake of foreign law. Mistake of foreign law is an excuse. Okay? The agreement can become invalid in that scenario because the law does not expect an Indian citizen to know the law of a foreign country. All right. And earlier we talked about the fact that mistake of a fact which is essential to the agreement by both the parties. What is the effect of that on the agreement? It makes the agreement void. Or in other words, the agreement is treated as if it never existed. All right. So with this, we have finished our concept of free consent. And I told you that free consent applies only if there is no coercion, no undue influence, no fraud, no misrepresentation, and no mistake. In first four scenarios, agreement is voidable. In this scenario, agreement is void. Okay. Tomorrow we are going to look at the next condition. I hope you remember where we started from. We were discussing agreement plus fulfillment of certain conditions is equal to contract. Only when all the conditions are fulfilled does an agreement become a contract. So far we have discussed two conditions: competency of parties and second, free consent. All right. So let's meet tomorrow and discuss the third condition. Thank you so much.